Morning, everyone. I am Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. Today is not your trial date, so I encourage you to speak with your attorney before speaking on the record, because everything that we say today is being recorded and can be used against you at a later date. If you are represented by the Public Defender's Office, attorneys from the Public Defender's Office are present both here in court with me and at the main jail. For those of you that are at other facilities, please know that these attorneys are available to you by phone. For those of you that are represented by private counsel, know that your attorneys come here to the courtroom with me to address your case from the courthouse. If your attorney is not present in the courtroom when I call you, then please let me know that so we can see how to facilitate you through that process. However, I ask you not to tell me that you have private counsel unless you or your family have retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. These persons are here to facilitate the morning session and to provide additional information if needed. Some of you may be able to resolve your case here at First Appearances for those of you that are here for misdemeanors and some municipal ordinance matters. Whether you are able to resolve your case today will depend on what is going on with you personally and what is going on with your case. If it is a felony or a violation of probation matter where a judge has already placed a no bond hold, then know that that cannot be changed or resolved here at First Appearances. After today, your case will be assigned to a division judge who will hear all pretrial motions and any subsequent trial in your matter. Before we get started today, let me just ask Mr. Reedy, has the jail requested that anyone be taken out of turn this morning?
No, Your Honor.
All right. Then I've only got one signed in at the moment, and that is the first in my stack, Miss Tarnisha Mack.
She's approaching, Judge.
Thank you.
Come on up, Miss Mack.
Good morning, Miss Mack. You're before the court this morning on one count of resisting an officer obstructing without violence. Count 2 is for aggravated battery with a deadly weapon. Count 3 is for aggravated battery with a deadly weapon. I do find probable cause for these charges. I understand that we have a family member present for Miss Mack. Hi, ma'am. How are you today? I'm sorry? You're her mother-in-law. Okay. So, ma'am, what I need you to understand is that since you're here without an attorney today, I'm not sure what your relation is to the case other than the fact that you are her mother-in-law. But I always remind everyone that everything we say is being recorded and can be used at a later date in this case. Do you understand that?
Yes, I do.
Okay. Do you still wish to say something? You can just tell me yes or no. If you wish to say something, some people come just to watch the hearing and some people actually want to tell me something.
I just want to know if she has
Well,
a bond.
just hold on, that's okay. Well, if you're just seeing if she has a bond, then that's all right. But if there's anything else that you want to tell me, then I'll have to place you under oath and then you can tell me whatever it is. Okay, you just want to see what the bond is? Okay. All right, then I will hear from the parties.
Good morning, Your Honor. Jason Goldsmith on behalf of the state.
Thank you.
For count 1, leave it in place, and then counts 2 and 3, $5,000 each, and no victim contact.
All right, Mr. Ribeiro?
Judge, my understanding is that Miss Mack basically has a clean record. Now, this non-in-custody case, my understanding the date of incident was last year, I believe in March. Since then, she's had no sort of contact with the alleged victim. My understanding is she's 19 years old, been living here her whole life. She is grateful that her mother-in-law and her fiance are there present. Basically, that's the person, or those are the people that she's going to be relying on to post her monetary bond. My understanding is her fiance is working, but he works at, I believe, at a temp agency / labor pool. So his financial resources are limited. He's not going to be able to afford the $10,000 which the state is asking for. Considering, Judge, this isn't recent, there's been no contact with the alleged victim. She has no extensive prior history, Judge. I'm going to be asking the court to consider $2,500 on count 2, $2,500 on count 3, a total of $5,000 on Miss Mack's behalf, Judge.
State. Does she have any priors?
Yes, Your Honor. In 2019, she had a resisting without violence. That was a withhold.
Is that it?
Yes, Your Honor.
All right. Though Ms. Mack does not appear to have an extensive history of priors, what concerns me in this case is that, yes, Mr. Romero, it is true that the main incident that's involved here did occur in March of 2019. However, the only reason that we have Ms. Mack here with us today is because law enforcement was called to a separate incident where she was found hiding in the closet. So at no point did she actually come forward with regard to this incident. And the incident that is at issue as far as March goes, the injuries that were sustained to the alleged victims were quite extensive. In fact, one of the victims sustained a broken eye socket. And based on the witness statements that were provided and included in the probable cause affidavit, I am concerned about some of the allegations that are here. So I am going to grant the state's request to impose a $5,000 bond on counts 2 and 3. I'll leave the standard bond in place on count 4. There will also be a no victim contact order in this case. I believe there are 2 alleged victims. So Ms. Mack, you need to understand that no victim contact means no phone calls, no text messages, no third-party contact, no social media with either of these alleged victims. Do you understand that?
Yes, ma'am.
All right, thank you very much. I have 2 MO cases for Mr. Shape. I don't know if they are present, but let me just see. The first one I have is Stephanie Starling.
Stephanie Starling? Not here at Main, Judge.
I know she was a medical reset before.
Last week, yeah.
Which facility is she at?
That's right, Your Honor.
Okay. Stephanie Starling, she's on page 3.
She also has,
Okay, good morning, Ms. Starling.
3 ml.
Good morning.
You are before the court on 5 counts. Each of them are misdemeanor capiases. I do see counts 1 and 5 are each MO municipal ordinance cases. Counts 2, 3, and 4 are standard misdemeanor cases. Yes, ma'am. That's her. Okay.
She's, I don't know. I've never heard any.
All right, I do find probable cause for the charges, and I will hear from the parties as to what's going on with Ms. Starling's cases. Mr. Shate?
Judge, my understanding is that she should be sent over to Judge Laura Run's division. So
Okay.
I guess we'll see her on Monday morning.
Okay. All right. Is Judge Lerner going to be able to get her on the docket for Monday? Is that what I'm being told?
Judge, I can call Joanne, her assistant. And have her
Okay. All right. So I'm going to have Ms. Starling's cases transferred to Judge Lerner Wren's division. And Ms. Starling, hopefully you'll be having a hearing in front of Judge Lerner Wren at the beginning of next week.
Okay.
Thank you. For now, the
Thank you.
standard bonds will remain in place.
Thank you, Judge.
Thank you.
Our Spanish interpreter is present, Judge.
Thank you. Other case that I have for Mr. Shea is Vernon Coleman. He's on page 10.
Judge at Main, he's approaching. Mr. Coleman, come on up.
Good morning.
Good morning, Mr. Coleman.
Good to see you.
All right. Mr. Coleman, you are before the court on 2 municipal ordinance violations. Let me just take a look so I can see specifically what they are. One of them is a trespassing charge, and count 2 is a possession of drug paraphernalia charge. I do find probable cause, and Mr. Shate.
Judge, due to the frequency of Mr. Vernon's coming before this court, the city of Fort Lauderdale is offering 3 days for Mr. Coleman.
I'm sorry, it's hard for me to.
They're offering 3 days, Judge, due to the frequency that Mr. Coleman is being arrested in the city of Fort Lauderdale.
3 days jail? All right. Okay. Mr. Coleman, if you would like to resolve these 2 cases, then the city's offer to you would be an adjudication in 3 days in the county jail. Would you like to resolve these matters today?
Yes.
All right.
How many cases is it, ma'am?
It's 2 charges. 2 charges. One is trespassing and one is possession of drug paraphernalia.
Yes.
All right. So,
There's no more cases?
not that I'm aware of. Is there anything else holding Mr. Coleman?
Nothing's holding him, Judge. I'm not aware of any cases that may be out there and
Okay.
about to come down the pike, but I think this is the only thing that's holding him.
All right. So, Mr. Coleman, this is the only one that I'm aware of at the moment. Okay? So, if you would like to resolve this matter, then raise your right hand. Do you swear or affirm to tell the truth?
I can't hear you.
Do you swear or affirm to tell the truth?
Yes.
All right. You can put your hand down. Mr. Coleman, do you understand everything that we've discussed here today?
Yes.
All right. Is anyone forcing you to resolve your case?
No.
Are you under the influence of any drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to a trial, but you are waiving that right by accepting a plea here today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that by taking a plea today, you will be subjected to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, Mr. Coleman, I accept your plea, and I find that it is freely and voluntarily given. Your sentence will be an adjudication and 3 days in the Broward County Jail.
I thought you said 2.
It's 3.
Thank you, Judge.
Thank you, Mr. Shea.
Great weekend.
You too. Those are the only 2 I had for you? All right. So, Mr. Reedy, with regard to the Spanish interpreter, do we know who's going to need his assistance?
A couple of people that require the Spanish interpreter.
Okay, who might that be?
On the last page of your docket,
Okay.
in the North Broward Detention Center, there is a Raul Gonzalez. Raul Gonzalez.
Okay, is there going to be anyone else? So I can pull them all out?
And the other one
Is this case, which facility is he at?
Sorry, it's the who did you need the Spanish interpreter?
Okay, all right. And for my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
I do. Esteban Rojas.
Thank you very much, Mr. Rojas.
That's right. Okay.
Good morning, Mr. Gonzalez.
Buenos días, señor González.
You are before
Good morning.
the court on an ad charge.
Usted está ante este tribunal por un cargo adicionado.
You have an immigration hold
Tiene una
with
orden de
no
captura
bond.
de parte de migración. Sin
There-
fianza.
That means that you will have to go before an immigration judge on this matter to address that.
Eso significa que usted deberá comparecer ante un juez de migración para abordar ese tema.
I find probable cause.
Considero que existen indicios probables
And Mr. Gonzalez, I wish you luck.
y le deseo suerte, señor González.
Thank you.
Gracias.
Okay.
Yeah?
And Mr. Reedy, who was the other person?
Immigration. No immigration.
You have the other one? Morning, Mr. Rego.
Buenos días, señora Urrego.
You are before the court on an ad charge.
Usted se encuentra ante este tribunal por un cargo adicionado.
This is an immigration hold
Esta es una orden de captura de parte de migración.
with no bond.
No hay fianza posible en este caso.
I find probable cause.
Considero que existen indicios probables
And Mr. Rego, this means that you will have to go before an immigration judge to address this matter.
y, señora Urrego, esto significa que usted deberá comparecer ante un juez migratorio para abordar este tema.
Good luck.
Buena suerte.
Is there anyone else that will need the assistance of the interpreter?
Not to the best of my knowledge, Your Honor.
Okay. All right, let me just go over to Mr. Romero. Mr. Romero, is there anyone at Maine that needs an interpreter? I just want to confirm before I let him go.
No one so far, Judge.
Okay, all right, thank you.
Thank you.
Okay. So I will continue going down our stack here. Brandy Boncheck,
I believe no problem.
thank you. Good morning, Ms. Boncheck.
Good morning.
You are before the court on a traffic capias. I find probable cause. Ms. Boncheck, you have a hearing before your division judge on Monday. Your bond is currently set at $250, and I'm going to leave that in place at this time.
Court would not consider pretrial release.
I'm sorry? This is a VOP hearing?
So it's not a capias, it's a VOP
Oh,
capias.
I do see it looks like she did not appear for a probation hearing. That's the issue. So, all right, so I'm gonna leave it in place at this time. Ms. Boncheck, you'll see your division judge on Monday.
All right.
Thank you. Amarante Joseph.
Waiting for the Creole interpreter, Your Honor.
Okay, all right, so I'll call Mr. Joseph back up when we have the Creole interpreter present. I'll put him to the side for now. All right.
She's gonna call you back. Creole interpreter.
Yolanda Bell,
She's a medical research honor.
thank you. Jill Donovan,
No problem.
all right.
Good morning.
Good morning, Ms. Donovan. You are before the court on one count of disorderly intoxication. I find probable cause. And Mr. Reedy, you advised that she would like to resolve this matter? State your
Yes, Your
nom-
Honor.
Yes, Your Honor, state's offers an adjudication with credit time served.
I'm sorry, what was that?
An adjudication with credit time served.
Okay, adjudication time served.
Did you hear that offer, ma'am?
Yes.
Is that what you'd like to do, adjudication time served?
Yes, please.
Okay.
All right, Ms. Donovan, will you raise your right hand for me? Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Do you understand everything that we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of any drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to a trial, but you are waiving that right by accepting a plea here today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that accepting a plea today will subject you to deportation or other immigration changes?
Yes.
What plea do you wish to enter, guilty or no contest?
No contest.
All right, Ms. Donovan, I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck.
Thank you.
Angeli Little.
Please approach the judge here, ma'am.
Thank you. Good morning, Ms. Little. You are before the court on one count of offering or agreeing to secure a lewd act. This is a prostitution offense. I find probable cause, and I'll hear from the parties if they wish to make argument.
Judge, in speaking to Ms. Little earlier today, she wishes to resolve this matter. We wanted to see if the state had a plea offer for her.
Your Honor, there's no offer by the state at this time. The defendant has priors for the same charge.
Okay.
Judge, considering this is a prostitution offense, the monetary bond right now is $300. It's nonviolent. We'd be inviting the court into plea negotiations with the court considering extending an offer if time serves.
I'm not going to do that at this time, Mr. Romero. Do you have any recommendation or request as to bond?
Judge, my understanding is Ms. Little does have a place to stay. She informed me she really doesn't know who could come up with the monetary bond, so she's asking to be released on pretrial release.
Thank you. State?
That's fine, Your Honor.
All right. In light of the fact that the state has no objection to the request and I have no issue with it based on the offense at this time, I will release Ms. Little to standard pretrial, so she will be released on her own recognizance. Ms. Little, you're going to be getting the information for pretrial services from your attorney there. You will need to report to pretrial within 24 hours. Today's Friday. You'll need to report to them by Monday. If you fail to do that, then a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right, and additionally, Ms. Little, it will be your responsibility to keep in touch with your attorneys and the clerk's office to know any future trial dates that you will need to be present for. Do you understand that? All right, thank you. Patricia Lane.
She's here, ma'am.
Thank you. Good morning, Ms. Lane.
Good morning.
You are before the court on one count for prostitution. I do find probable cause, and I will hear from the parties.
Judge, after speaking with Ms. Lane, she wishes to resolve this matter. She wanted enough to say it had a plea offer for her.
State's offer is an adjudication, time served.
She wishes to accept the state's offer, Judge.
All right, very well. Ms. Lane, will you please raise your right hand? Do you swear or affirm to tell the truth?
I do.
All right, Ms. Lane, do you understand everything that we've discussed here today?
Correct.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of any drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You can put your hand down. Do you understand that you have the right to a trial, but you are waiving that right by accepting a plea here today?
Correct.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that accepting a plea today will subject you to deportation or other immigration changes?
Correct.
What plea do you wish to enter, Ms. Lane? Guilty or no contest?
Nope.
All right.
What's your plea? No contest.
Thank you. I accept your plea, and I find that it is freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck to you, Ms. Lane. Brenda Cooper.
This is medical reset.
Reset?
Yes, ma'am.
Okay. Beverly Walker.
No problem.
Thank you. Good morning, Ms. Walker.
Morning.
You are before the court on one count of trespassing. I do find probable cause, And I will hear from the parties if they wish to be heard.
Judge, I have some concerns about Ms. Walker. As the court can see, she's, even as we speak, making some unusual gestures.
Okay.
I think this case is one that could be well transferred to Judge Lerner Wren.
I would agree with you, Mr. Reedy, and at this time I'll sign an order transferring her case to Judge Lerner Wren. If the state would get in contact with her judicial assistant and see if she can have her set for a hearing early next week if possible.
Okay.
Thank you.
Come on.
Wait, Sam, this is my time to.
Precious Aviles,
Medical reset.
thank you. Vivian Cobb,
Medical reset. So,
thank you. Quinika Murray. Yes. Yes.
Even though she's gonna be a medical reset
Yes.
for tomorrow's, magistrate purposes on the final,
Yes.
can you please correct count 4 to reflect a VOP?
Count 4 is a VOP.
Yes, ma'am, misdemeanor.
Okay.
So that way tomorrow when they reprint, they'll
All right.
have a VOP.
So I'm not going to scratch it up. I'll cross it out and just write VOP.
Yes, ma'am. All right, thank you. Count 4 is a misdemeanor.
Next up is Quinika Murray. Thank you. Good morning, Ms. Murray. All right, Ms. Murray, you're before the court on count 1, grand theft. Count 2 is resisting an officer or obstructing without violence. I find probable cause, and I will hear from the parties if they wish to make argument.
Judge, Ms. Murray is wishing to be released on pretrial release on this nonviolent offense.
State. Does she have any prior state? Okay. All right. Ms. Murray, I will be releasing you to standard pretrial. You're going to get the information there from your attorney regarding pretrial services. You will need to report to them no later than Monday. If you fail to report as instructed, a warrant will be issued for your arrest. Do you understand that?
Yeah.
All right, and Ms. Murray, additionally, you'll be responsible for keeping in touch with your attorneys and the clerk's office to know any future trial dates that you need to be present for. Do you understand that?
Yes.
All right, thank you very much. Sania Rivera,
Ms. Rivera, come on up, please. She's approaching, Judge.
thank you. All right, thank you. Ms. Rivera, you're before the court on count 1, grand theft. Count 2 is first-degree petty theft. I do find probable cause, and confinement has advised that your bond has been posted.
Beautiful. Your sister already bonded you out? To the left.
Wanda Daniels,
Ms. Daniels, come on up, please. She's approaching, Judge.
thank you.
Miss Ma'am,
Ms. Daniels, good morning.
good morning.
You're before the court on count 1, prostitution. Count 2, selling cocaine. Count 3, possession or use of drug paraphernalia. I find probable cause, and I will hear from the parties if they wish to make argument.
Judge, Ms. Daniel is requesting to be released on pretrial release on this nonviolent offense. My understanding is she's financially indigent at this time. She's not working. She is homeless. She's been here her whole life. She did advise me she will be coming back to court to face these allegations, but no one can afford to post her bond, so that is why she's requesting the court releasing her on supervision.
State. dates in it?
17.
State is advising that she has multiple failure to appear within at least the last couple of years. State, what's your recommendation?
Our state's recommendation is to keep the bond as is.
What's your priors?
Your Honor, in 2018, she had possession of cocaine that she was adjudicated 364 days. 2017, petty theft, she was adjudicated. 2017, for prostitution, she was adjudicated. 2015, possession of cannabis, of cocaine, possession of drug use and paraphernalia, and also for prostitution, she was adjudicated with 36 days. 2013, possession of cocaine, possession of cannabis, possession of drug use and paraphernalia, she was adjudicated as well. 2010, possession of cannabis, for withhold. 2007, possession of cocaine, possession of drug use and paraphernalia, she was adjudicated. 2004, possession of cocaine, prostitution, possession of drug use and paraphernalia, she was adjudicated. 2002, burglary, a conveyance unoccupied, and grand theft, she was adjudicated. 2001, possession of cocaine, trespass, she was adjudicated on that. 2000, possession of cannabis, she was adjudicated. 2000, possession of cocaine and possession of drug use and paraphernalia.
Based on Ms. Daniels' extensive history and the fact that she's got multiple failures to appear in her history, as well as no current permanent address, based on what Mr. Romero has advised, I'm going to leave the bonds in place at this time.
Our Creole interpreter is present, Your Honor.
Thank you very much. Let's go back to Emirante Joseph. That was North Road. Good morning, Ms. Sinaj.
Good morning.
Will you raise your right hand for me, please? Do you swear or affirm to interpret from Creole to English and English to Creole to the best of your ability?
I do. Vivian Sentinel.
Yes.
Thank you, Ms. Sinaj. All right. Good morning, Ms. Emirante.
Bonjour,
Good morning.
Okay, or Ms. Joseph, excuse me. All right, Ms. Joseph, you are before the court on one count of trespassing.
Pour yon accusation pour entrer en côté illégal.
I do find probable cause.
Nous jouons une cause probable.
Mr. Reedy, based on some of the information provided in the probable cause affidavit, I may be inclined to transfer this to Judge Lerner Wren. Do you have any objection to that?
I think that would be a very good idea, Judge.
Transféré par juge le Noren. Est-ce qu'il y a un problème avec ça? Non, juge, je pense que c'est bon idée.
All right, Ms. Joseph, I'm going to be transferring your case to Judge Lerner Wren,
Transféré car Ms. Joseph par juge le Noren.
and you will hopefully have a hearing before her toward the beginning of next week.
Wap ka wè ansama avè li nan komanseman lot semen.
Thank you.
Merci.
Thank you.
Does anyone else need a Creole interpreter?
Est-ce que gen lot moun ki bezwen interprète kreol?
All right, thank you, Ms. Sinaj. Yvonne Mullins. Jennifer Rodriguez.
She's approaching, Judge. You're at me. Come on up, ma'am.
Good morning, Ms. Rodriguez.
Good morning.
You are before the court on 2 counts. Count 1 is child neglect without great bodily harm. Count 2 is for child neglect without great bodily harm. I do find probable cause for these charges, and I will hear from the parties as to bond.
Judge, the state is going to be asking, Matt Lopez for the state, Your Honor, the state's going to be asking for a $75,000 bond on each count. This was a 3-month-old baby with over 25 bone fractures and multiple scratches. The nurse who investigated the case determined that those fractures are inconsistent with it being an accidental fracture. So just based on the severity of the facts, the state would ask for a $75,000 bond on each count, no contact with the co-defendant, and no contact with the baby.
Just confirm, state, I want to make sure I have everything down. You had 75,000 each, no contact with co-defendant, no contact with baby?
Correct, Your Honor.
All right, Mr. Romero?
Judge, I understand the nature of the allegations. However, my understanding is the date of incident was earlier last year. My understanding, Judge, is Ms. Rodriguez went through dependency court already. This was investigated. My understanding, Ms. Rodriguez submitted herself to some sort of therapy, parenting classes. She, through Banyan, submitted herself through therapy. And then, most importantly, Judge, she voluntarily surrendered her parental rights. So she had no sort of contact with the child or infant. So as far as the state's special request of no contact, we have no objection to that. Having said that, Judge, since she was going to court, she was going to dependency court, she's not a flight risk, she's not trying to flee this jurisdiction or anything like that, Judge. I believe what the state is asking for as far as the monetary amount is excessive. The whole purpose of this bond is to assure her presence here in court. She's had no further contact with the child, as evidenced by her surrendering her parental rights. Now, she is working, she's self-employed, she makes cosmetic jewelry. She's 31 years old. She's been living in Suffolk for the past 26 years. My understanding, Judge, is that this is her first time being arrested. She has a clean record, very strong ties to community. She lives in Hollywood with her boyfriend. Her boyfriend and her work together. They both make cosmetic jewelry. So I'd ask that the court not impose the no contact order regarding both co-defendants. And she has other family members that live in our community that she's going to be reaching out to help post her monetary bond. Specifically, her mother. Her mother is going to be is going to be helping her out with their bond, but her mother's not going to be able to come anywhere close to what the state is asking for. So I'm asking for a reasonable bond on Ms. Rodriguez's behalf, Judge.
Add that,
Make sure you're speaking to the microphone so they can hear you.
if I may just also add that there was a capias out on this case and the co-defendant's case, so there's also a concern here that she's a possible flight risk.
Somewhat.
Oh, okay. Sorry, Your Honor. So I would still, the state would still ask that the $75,000 bond on each count be granted.
Oh.
Was there a flight risk order issue?
No, Judge.
Okay, right, it was a non-custody capias that was issued.
Right, Judge. And when the state refers to a capias, a non-in-custody capias, is not the same thing as a capias, as the court is well aware.
That is correct. Mr. Romero, when did she surrender her parental rights?
August of 2019? August 2019, Judge.
Who has custody of the child now?
Judge, my understanding, the child now is under foster care. I believe there's been a home study conducted and her parents'
The paternal grandparents
are
taking classes so they can adopt him.
are taking steps to adopt the child.
Allegations that are included in the probable cause affidavit are obviously very serious, especially with regard to the injuries that the 3-month-old infant presented with to the hospital when this incident occurred. While I am taking that into consideration, I do also take into consideration the fact that Ms. Rodriguez has voluntarily surrendered her parental rights and no longer has custody of the child, which, in light of what seems to be going on here, may or may not be, a good decision in this case. Based on the fact that she did we confirm, did she self-surrender in this case?
I can't confirm that, Your Honor.
Okay. All right, based on the action that had been taken from the defendant, I'm not sure, that there is an actual flight risk issue going on in this case, but these are very serious allegations. So in light of that, I'm going to impose a $25,000 bond on each count. I am going to order no victim contact. I understand that she doesn't have custody of the child, but whether the child goes into custody of relatives in the future or not, I want to make sure that that order is in place. I am also going to order that she has no contact with the co-defendant. I understand that they reside together, but obviously they are both facing the same serious allegations, and I don't want to raise any additional issues as a result of that. So until further order of the court, there will be a no contact order with regard to the co-defendant as well. Ms. Rodriguez, so that you understand what the no contact orders mean with regard to both the child and to the co-defendant. No victim contact and no contact with the co-defendant means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes.
All right, thank you. I am Bailey. Yes.
Mr. Bailey, come on up, please.
Do we have a correction on Mr. Bailey's case? Okay.
It says count 2, child abuse.
Yes.
It's battery.
Count 2 is supposed to be a battery
Yes,
count?
it's not.
Can I just take a look? Thank you very much. All right. So confinement has advised that we have a correction to the original booking sheet. The corrected charges are as follows. Mr. Bailey, you are before the court on 1 count of felony battery, domestic violence. Count 2, touch or strike battery. Count 3, tampering in a 3rd-degree felony proceeding. I find probable cause, and I will hear from the parties as to bond.
Your Honor, the state's recommendation for bond is $50,000 for each count. With regards to the facts of this case, it is pretty serious that the defendant had battered this victim, had punched her in the face multiple times. She was trying to get help, and there's a concern for integrity for the judicial process and victim tampering. The defendant has 2 cases prior that were null pros by the state, but were against the same victim in this case. 2018 and 2017, so the state would also ask for no victim contact.
Judge, what the state is asking for $100,000, I believe is excessive. My understanding this took place earlier last year. Since then, Mr. Bailey has only had limited contact for the purposes of just providing financial support to his children. Having said that, Judge, he has no problem abiding by the state's request as far as no contact. He's 31 years old. He's been here in our community for over 5 years. He works in construction. He's been with the same construction company for 1 year. Now, I see the state mentioned that he has two previous arrests for DV with the same alleged victim, but Judge, it's the state that chose not to go forward on the charges. Having said that, Judge, he lives in Plantation. He rents a room. He's been renting that room now for about 1 year, paying about $600 per month. Judge, I'm going to be asking for the court to set, considering his financial situation, Judge, and most he can afford is about a $2,000 bond on count one, $1,500 bond on count two. So we're going to be requesting a total of $3,500 on Mr. Bailey's behalf.
In regards to the prior battery, the state misspoke and said 2018. One was 2019 and the other was 2017.
Are there any priors besides those two cases?
No.
Sorry. On count one, I'm going to impose a $10,000 bond. On count two, I'm going to impose a $7,500 bond. I'm going to leave the standard bond in place on count three. I'm also going to impose a no victim contact order. My understanding is that in this case, there are two alleged victims. The no victim contact order will apply to both of those individuals. I'm also going to impose a no return order to this residence. I'm not sure if these two individuals still reside at this residence, but assuming that they do, there will be a no return order to that location. Mr. Bailey, so that you understand, no victim contact means no phone calls, no text messages, no third-party contact, no social media, and no return means that you are not to return to or appear at the residence that is at issue in this case. Do you understand that?
Yes, ma'am.
All right. Caesar? Thank you.
He's in Conte, Judge.
All right, thank you very much. Good morning, Mr. Caesar.
How you doing?
I'm well. Mr. Caesar, you're before the court on some ad charges. Count 5 is battery, causing bodily harm, domestic violence. Count 6, false imprisonment of an adult. Count 7, obstructing or depriving of means of protection or communication. Counts 8, 9, 10, 11, and 12 are each surrender of surety bonds in felony cases, I believe. I just want to confirm that's correct.
Our state would ask for ROR for 5, 6, and 7.
Seeing ROR on 5, 6, and 7?
Seems like they're just, the bond surrenders are the same charges as 5, 6, and 7.
Okay.
No one closed the 5, 6, 7, and, later on.
Right.
Because he's already held on the other cases, he has bonds and no bonds on it.
Okay. All right. I do find probable cause, and I will grant that request. Counts 5, 6, and 7 will each be an ROR. Thank you, Mr. Caesar. Okay. Anthony Salgado.
She's in North Broward, if I could have just a minute.
Yep.
Judge, it appears as though this is an incident from 2016 where Mr. Salgado did not pay a tab, and that's the gist of the charge against him. Mr. Salgado indicated to me that he really doesn't want to take a plea, but he does not have the $250 to bond out of jail. He can stay with his mother, and he would be living with her. He's also a veteran. He received an honorable discharge. He served from 2006 until 2014. In light of the age of the case and the fact that he would be staying with family, I would ask the court to consider releasing him on his own recognizance.
Just for the record, Mr. Salgado, this is a misdemeanor capias stemming from a petty theft charge. It appears that you didn't appear for your arraignment in 2016, so I do find probable cause. State, do you have a recommendation? What's the most recent? Is that pending or was that? What I will do is I will RR him to standard pretrial. All
Very
right?
good, Judge.
So, Mr. Salgado, just so that you,
Thank you, Your Honor.
okay, just so you understand, you're going to be getting some information about pretrial services before you're released. You will need to report to them no later than Monday. If you fail to report to pretrial, then a warrant will be issued for your arrest. Do you understand that, Mr. Salgado?
Yes, ma'am.
All
Yes, Your
right,
Honor.
and I understand that this is a 2016 case, but just because you're being released today doesn't mean that's the end of the case. So it's going to be your responsibility to follow up with your attorneys and the clerk's office to know any future trial dates that you need to be present for. Do you understand that?
I do, Your Honor.
All right, thank you.
Thank you.
Good luck,
everyone.
Mr. Salgado.
Thank you. Thank you, Attorney.
Jatadia Brown. Which facility is Mr. Brown at? Okay, thank you very much. Good morning, Mr. Brown. You are before the court on a capias for a misdemeanor case. I find probable cause. The bond is presently set at $5,000. I will hear from the parties.
Judge, considering as a court date this Monday, nothing to add from the defense at this time.
All right, in light of that, I will leave the bond in place and Mr. Brown will go before his division judge on Monday. Junior Dallencourt.
He's approaching, Judge.
Thank you. Good morning, Mr. Dallencourt. You are before the court on count 1, resisting an officer, obstructing without violence. Count 2 is trespassing of an unoccupied structure or conveyance. I find probable cause, and I will hear from the parties.
And speaking of Mr. Downcourt, he wishes to resolve this matter. We want to see if the state has a plea offer for him.
State. They're not willing to make an offer at this time because there is another pending trespassing case that was just filed on the 7th. Do you have any other request or recommendation?
One moment, Judge.
Do you have a recommendation on this case?
Judge, nothing to request then at this time.
Thank you.
Yeah, because it's the same location that being discussed.
Well, I believe this case was dealing with a vehicle, so I'm not sure what location it is that you're referring to.
This is date of, place of arrest is 1200 Northwest. Oh, sorry, different address, sorry.
Here's your recommendation for bond state.
Judge, we'd like to keep the bond that's already there.
All right, I'm going to leave the standard bonds in place. Thank you.
Thank you. Oh, by the way, this is Yannia here, sorry, on behalf of the state.
Thank you. William Jumper.
Mr. Jumper's approaching, Judge. I mean, come on up,
Thank you.
Mr. Jumper.
Good morning, Mr. Jumper.
Good morning.
You're before the court on a misdemeanor capias. This was a charge for criminal mischief. I find probable cause, and I will hear from the parties if they wish to make argument.
Judge, at this time, nothing to add from the defense.
Okay, state, anything? All right, the standard bond will remain in place. Rohan Bahari,
Approaching East Main.
thank you. Good morning, Mr. Bahari. You're before the court on a misdemeanor capias stemming from a charge for driving with an expired driver's license. I find probable cause. I'll hear from the parties if they wish to make argument.
Judge, Bahari, he wishes to resolve this matter. We want to see if the state had a plea offer for him.
State, do you have an offer?
Yes, Judge, our offer is a withhold court costs.
I didn't hear.
It's a withhold and court costs.
Judge, he wishes to accept the state's offer.
All right, thank you. Mr. Bahari, will you raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Do you understand everything that we've discussed here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor.
Do you need any more time to speak with your attorney?
No, Your Honor.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea here today?
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
No, Your Honor.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, Your Honor.
And Mr. Bahari, what plea do you wish to enter, guilty or no contest?
No contest.
Okay, thank you. I accept your plea. I find that it is freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs. Thank you and good luck, Mr. Bahari. Arthur Cobwell.
Mr. Cabo is a medical reset judge, I've been asked.
His bond has been posted. All right, so on Cobwell, I'll find probable cause, and I'm sure when they get to him, he'll be out. Anthony Corfrey. Thank you.
He's approaching, Judge.
Okay.
At Maine. Morning, Your Honor.
Thank
He
you.
declined the services of public defender. He's going to be hiring private counsel, Judge.
Good morning, Mr. Corfrey. For the record, you're before the court on one count of touch or strike battery. I find probable cause, and Mr. Corfrey, I've been advised that your bond has been posted.
Thank you.
Thank you. Jennings Bennett.
Mr. Bennett?
Good morning, Mr. Bennett.
Good morning.
You are before the court on one count of possession of cannabis, 20 grams or less. I find probable cause, and I'll hear from the parties if they wish to make argument.
Yeah, man. Hold on one second. Judge, considering this is a misdemeanor possession of cannabis, I don't know if the state has an objection to having him release ROR.
Does he have any priors? Are they recent? All right, Mr. Bennett, I'm going to release you on your own recognizance. I need you to understand that just because you're being released today, that does not mean that that is the end of your case. It will be your responsibility to keep in touch with your attorneys and the clerk's office to know any future court dates that you need to be present for. Do you understand that?
Yes, ma'am.
All right, thank you. Kermit Silva.
So, he's approaching, Judge.
Thank you. Mr. Silva, good morning.
Good morning.
You are before the court on a misdemeanor capias. This is stemming from a battery charge. I find probable cause, and I'll hear from the parties if they wish to make argument.
Judge, anything from the defense?
Anything from the state?
The state requests no victim contact and to leave the bond.
All right. I will leave the standard bond in place. There will also be a no victim contact order since this is a battery charge. Mr. Silva, so that you understand, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
All right, thank you.
I'll call your friend's push phone. Mr. Jackson?
Travaris Jackson,
He's approaching, Judge.
thank you. Mr. Jackson, good morning.
Good morning.
You are before the court on a traffic capias. This is stemming from a charge for driving with a suspended license. I find probable cause, and I'll hear from the parties if they wish to make argument.
Yeah, Judge, and speaking of Mr. Jackson, he wishes to resolve this matter. I believe he actually surrendered himself on this outstanding capia, so we wanted to know if the state has a plea offer for him today.
State.
Judge, the state's offer is adjudication time served.
Adjudication, time served.
He wishes to accept the state's offer, Judge.
All right, Mr. Jackson, will you raise your right hand for me, please? Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Do you understand everything that we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of any drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to a trial, but you are waiving that right by accepting a plea here today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea here today will subject you to deportation or other immigration changes?
Yes, ma'am.
And Mr. Jackson, what plea do you wish to enter, guilty or no contest?
No contest.
All right, thank you. I accept your plea. I find that it is freely and voluntarily given. And Mr. Jackson, once again, your sentence will be an adjudication, time served. Good luck. Joseph Petrie,
Mr. Petrie, come on up, please. He's approaching, Judge.
thank you. Mr. Petrie, good morning.
Good morning.
Mr. Petrie, you are back before the court this morning on some ad charges. Counts 9, 10, 11, and 12 are each a charge for burglary of an unoccupied structure unarmed. Counts 13, 14, and 15 are each a charge for grand theft. Count 16 is a charge for second-degree petty theft. Counts 17 and 18 are each counts for dealing in stolen property. Counts 19 and 20 are each counts for false ownership information provided for pawned items, $300 or more. I find probable cause. I'll hear from the parties.
Judge, Mr. Petrie, as you recall, was here yesterday on
Yes.
similar offenses, I believe, on counts 1 through 8. After the court, having heard from the defense, I believe the court agreed and released, to the best of my recollection, on level 2 pretrial Elmo. He's going to be living in Deerfield Beach. He has a job waiting for him. It's at Royal Cuts. He's a barber. I do understand, I believe he had prior contact with the system, but I believe it was a little dated. It was about over 10 years ago. Considering these are nonviolent, these are serious, these are a similar offense. Judge, I'm asking if the court would also on these offenses release Mr. Petrie on level 2 pretrial.
State.
As he did receive further charges, we're requesting a $3,500 bond on charges 9 through 12 and pretrial release by CPS to continue that.
Did I ROR him on counts 1 through 8? Remind me again, Mr. Petrie, as far as his priors go. right, in light of the new charges and allegations that have come to light for Mr. Petrie, I'm not going to ROR him on the remaining charges. Obviously, we have a lot of new information that's come into play as a result of the ad charges and new allegations that have been brought. Based on this information, I'm going to impose a $1,000 bond on counts 9, 10, 11, and 12. Additionally, on counts 17, 18, 19, and 20, those will be reduced to $1,000 each. If Mr. Petrie does bond out, he will be released to pretrial and placed on a level 2 GPS monitor, as we previously discussed. I believe that I also imposed a no return order with regard to the prior charges. That order will stand with regard to the ad charges as well. Thank you. Alexander Duarte.
Mr. Duarte, come on up, please.
Mr. Duarte, good morning.
Good morning.
You're before the court on ad charges, counts 4, 5, 6, 7, 8, 9, and 10 are each an ad charge for burglary of an occupied conveyance unarmed. I find probable cause, and I will hear from the parties.
Judge, Mr. Duarte was here yesterday. To the best of my recollection, my understanding, I believe he was here before you on 2 burglary of dwellings, and I believe resisting without violence, something along those lines. I believe the court set a total of $10,000 bond. I believe Mr. Duarte, when the state brought up he had a prior, I guess, case that went through diversion. He's been here his whole life. He's 20 years old. I did inform the court that he just got a job as a host at Chili's. The Chili's located across the street from Sheridan Tech. He lives in Cooper City with his father. His father's going to be the one helping post his monetary bond. Judge, considering what we have before you, I believe that you're third-degree felonies. I'm going to be asking for the court to consider setting a $1,000 bond on each count.
State.
Judge, the state is requesting a $5,000 bond on the burglary of occupied dwellings charges and a $2,500 bond on the conveyance charges.
Charges are already at $5,000 each, is that correct?
Yes, you're correct, Your Honor.
So he has a total of $10,000 bond right now?
He has 1 and 3 already has 5,000 each.
Right. I will impose a $1,500 bond on counts 4 through 10. I'm also going to impose a no return order. I understand that based on the new allegations included in the probable cause affidavit, some of these locations may be in the same neighborhood or vicinity that Mr. Duarte resides in. So he needs to understand that there will be no return to the locations that are at issue as a basis for the ad charges 4 through 10. Additionally, there's going to be a no victim contact order. Mr. Duarte, no victim contact means no phone calls, no text messages, no third-party media, no third-party contact, no social media. Do you understand that?
Yes, I understand.
All right. you. Charles Clayton,
Mr. Clayton, come on up. Please approach the judge.
thank you. Mr. Clayton, good morning. You're before the court on 2 ad charges. Count 6 is grand theft of a firearm. Count 7, possession of weapon or ammunition by a convicted Florida felon. I find probable cause, and I'll hear from the parties.
Judge, I know he came before you, I believe either yesterday or the day before yesterday. Yesterday? I think he has about a $16,000 bond. He's having trouble, as it is right now, coming up with that monetary bond. My understanding, Judge, is he works for A1 or A-Star Roofing. He supports a lot. He has 10 children. His girlfriend is the only person that's going to help post his monetary bond. My understanding, she's a bartender. He's been here his whole life. He lives locally here in Miramar, Judge. Judge, as it is, he has kids that he has to support.
So, Mr. Romero, what's your recommendation?
Judge, I'm going to be asking for a $1,000 bond on count 7.
State.
Judge, as there were shots fired and he does have 9 felony convictions, the state would recommend $10,000 as well as no victim contact and surrender of all weapons.
Judge, I do understand what the state is saying as far as the serious nature of the allegations, but I believe that serious allegation was actually addressed in yesterday's bond amount, which is, I believe, set at $16,000. Before this, I believe his last contact, or he's been clean for about 5 years. So, Judge, he just simply can't afford any more. So that's why I'm asking on count 7 a $1,000 bond.
Can we just confirm what his current total bond amount is as a result of the initial charges?
$16,500.
Count 6, I'm going to leave the standard bond in place. On count 7, I'm going to impose a $3,000 bond. I believe that no victim contact order was put in place as a result of the initial charges. That will apply to the ad charges as well. Additionally, I believe that this order was placed yesterday as well, but in the abundance of caution, there will be an order that Mr. Clayton possess no weapons, ammunition, or firearms. If he does have any of those in his possession, he is to surrender them until further order of the court. Mr. Yes, so since I put him on pretrial level 2 for the other ones, the same conditions will apply to the ad charges. If he bonds out, he will be placed on pretrial release level 2 with GPS. All right, and Mr. Clayton, I believe that we discussed this yesterday, but so that I can repeat myself, no victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Ma'am, I don't even know the victim.
Okay, well, that's not the allegations that are included in the initial probable cause affidavit, so just heed my warning, no victim contact until further order of the court.
Good luck.
Kevin McElroy.
Judge, he is approaching, and I asked him if he wanted to apply for public defender. He declined. He said he's going to hire his own private attorney.
I didn't decline. I said my family, I didn't contact my family yet. They were supposed to, I don't know if the lawyer there or what.
Judge, I'm hearing something different now.
All right,
So, if
Mr.
I could have one
McElroy,
moment to speak to
let's
him.
get on the same page here, Mr. McElroy.
Yes, ma'am.
Do you
Good morning.
understand that you are entitled to have an attorney represent you for this hearing?
Yes.
All right, there is no private attorney that is present here for you today. Do you want the public defender's office to represent you for this hearing?
Yes.
All right, Mr. Romero, do you need any additional time to speak with him?
Oh, yes.
All right, I'm gonna put him to the side, and you let me know when he's ready. Michael Milla.
Please here, present, Judge.
Thank you. Good morning, Mr. Milla. You are before the court on count 1, aggravated battery with a deadly weapon. Count 2, touch or strike battery. Count 3 is a civil writ of arrest. Count 4 is a misdemeanor capias. I find probable cause, and I will hear from the parties.
Judge, the state is asking for a $5,000 bond on count 1 and that the other bond amounts remain. It seems like Mr. Miller has a history of violent behavior. In 2013, there was a battery that was no pros by the state. 2012, there was an aggravated battery on a pregnant female that was no pros by the state. That's why we're asking the amount we are, along with no victim contact, and that he's to possess no weapons, firearms, or ammunition.
The only two priors, the two cases that you cited?
There was also a resisting and a trespass in 2007, an unlawful use of false name, possession of cannabis, and driving license suspended in 2018, and that's the information the state has at this time.
Mira?
Judge, first, I wasn't able to hear everything clearly what the prosecutor was saying, but I believe they referred to a prior 2013 offense with the same victim, which was dropped. My understanding, Judge, is the state that chose not to go forward, and my understanding is the actual victim came forward, and I believe either spoke to the state attorney's office or actually came forward in court, admitting that nothing took place under oath. Having said that, Judge, my understanding in count 1, I know the state is asking for $5,000 bond. As it is right now, with the other bonds in place, it's going to be tough for his family to come up with. My understanding is the alleged victim, we have no problem as far as having no contact. My understanding, the alleged victim was the ex-boyfriend of the mother of Mr. Miller's child, in which I believe there was allegations in which that victim abused the child. My understanding is the child's mother has since filed a restraining order on that victim so that that victim has no contact with Mr. Miller or his child. Judge, I do understand though that the allegations are serious. He's 30 years old. He's been here for 20 years. Right now he's not working. He's looking for work. He lives in Davie with his girlfriend. My understanding, Judge, that's the person that's going to help post monetary bond. They've been residing at the same place for 2 years. As you could see, financially he's been tough. He has a child support purge amount on count 3 of $900 as it stands right now. So, Judge, considering the circumstances, I'm asking for a $1,000 bond on count 1, considering he has all these other matters that he has to come up with.
I'm going to impose a $3,000 bond on count 1. The other standard bonds will remain in place. I do see that Mr. Milla has a hearing before his division judge on Monday. In the meantime, there will be a no victim contact order as well as a no return order to this residence where this occurred. Additionally, I'm going to order that Mr. Milla possess no weapons, firearms, or ammunition. If he is in possession of any of those items, he is to surrender them until order of the court. Mr. Milla, do you understand that no victim contact means no phone calls, no text messages, no third-party contact, no social media?
Ma'am. Yes, ma'am.
And for the record, Mr. Romero, I know you were referencing the mother's ex-boyfriend is one of the alleged victims, but it does appear that the mother of the child is also one of the alleged victims in this case, so that no victim contact order will apply to both of those individuals.
And the mother of the child is on count 2, correct?
That is correct.
Yeah.
All right. Jarrell Neal.
Medical reset.
Thank you. Ramel Davis.
Please approach the judge.
Thank you. Mr. Davis, good morning.
Good morning.
You are before the court on count 1, resisting an officer or obstructing without violence. Count 2 is a felony violation of probation. Count 3 and 4, those are also felony probations of violation. Those have no bond holds on them. As a result of that, I'm going to leave the standard bond in place on count 1. And Mr. Davis, I do see you have a hearing before your division judge on Monday. I find probable cause. Thank you. Lee Anthony Drummer.
Please approach the judge.
Mr. Drummer, good morning. Mr. Drummer, you're before the court on a parole violation. That has a no bond hold and means that you will have to go before the parole board to determine what's going to happen with this matter. I find probable cause. Joseph Pesci.
Please approach the judge, Maine.
Mr. Pesci, good morning.
Good morning.
You're before the court on 1 count of burglary of an unoccupied structure unarmed. I find probable cause, and I will hear from the parties if they wish to make argument.
Judge, I'm speaking to Mr. Pesci. Unfortunately, he's homeless at this time. He's not working, so he has no income coming in. He doesn't know who, if anyone, could post his monetary bond. He's been here in South Florida since 2012. He's 29 years old. He has prior contact with the criminal justice system. From what he advised me, he's been 3 years clean. So, Judge, on this nonviolent offense, we're asking the court to consider releasing Mr. Pesci on pretrial release.
Judge, the state would be asking for a $3,000 bond. The defendant was adjudicated guilty of grand theft back in 2018 in St. Lucie County, has an open drug paraphernalia case in St. Lucie County. So the state would ask for $3,000 bond and a no return.
$2,000 bond and a no return order. So, Mr. Pesci, no return means that you are not to return to or appear at the location that is at issue in this case. Do you understand that?
Yes, ma'am.
Thank you. William Candelario.
Candelario, come on up, please. Judge, he's approaching me.
Thank you. Mr. Candelario, good morning.
Good morning, Your Honor.
You're before the court on 2 counts. Each count is for child neglect without great bodily harm. I find probable cause. I will hear from the parties if they wish to make argument.
Judge, this is the co-defendant case where Your Honor imposed a $25,000 bond on each count.
Yes.
So the state would be asking for all same terms and conditions for this defendant.
And Judge, Mr. Candelario kind of sits in a similar position. He also, this incident, I believe, took place early last year. He also voluntarily surrendered his parental rights. He's had no contact with the victim. My understanding is I believe he has 1 prior contact with the criminal justice system, which was a grand theft, nothing related or similar to this offense at all. And that was, I believe, back in 2012. Like I said before, he works with the co-defendant, I believe, selling cosmetic jewelry. They're not in a financial position to come anywhere close to what the bond was set on the previous co-defendant of $25,000 each to $50,000. He's been living in South Florida for 16 years. He's 30 years old. Him and the co-defendant share an apartment in Hollywood, and their monthly rent is $995. So, Judge, I'm asking you to take that into account in determining reasonable release conditions for Mr. Candelario.
Thank you. All right, as I said in the prior case with the co-defendant, while I do understand that both of the defendants did voluntarily surrender their parental rights, the allegations in the probable cause affidavit are very serious in nature. In light of that, I am going to impose a $25,000 bond on each count. The same conditions will apply as in the other case, and those will be no victim contact. I understand, once again, Mr. Candelario, that you and the co-defendant have each voluntarily surrendered your parental rights, but I do understand there's a possibility that some family members may be gaining custody, so the no victim contact order will remain in place until further order of the court. I am also going to add, the same as I did on the other case, there will be no victim with the co-defendant until further order of the court. I understand that these two individuals reside together, but one of them will have to find a different place to stay if they do bond out, because that order will remain in place until further order of the court. Mr. Candelario, for clarity, no victim contact and no contact with your co-defendant means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes, ma'am.
All right, thank you. John Cassidy. Mr. Cassidy, good morning.
Good morning.
You are before the court on one count of aggravated battery with a deadly weapon. I find probable cause, and I'll hear from the parties.
Honor, based on the fact that the defendant allegedly stabs someone with a knife on the chest, and that he has a battery that was no info back in 2016, an ag assault that was no infoed back in 1992, but it does show a pattern. The state would ask for a $10,000 bond, no victim contact, no return to the location of the incident, surrender, and no weapons, firearms, and ammunitions.
Judge, that's going to be almost financially impossible for Mr. Cassidy. He's homeless. He gets disability. He gets, I believe, approximately $550 a month. Now, he has no problem with the alleged, with the request as far as no contact with the victim. He is looking forward to disputing these allegations. He's 63 years old, been here since 1989. But Judge, he's not going to be afforded what this state is asking for. We're asking for the court to consider a $2,000 bond on Mr. Cassidy's behalf, considering his financial circumstances.
State, you requested a no return order. From what I'm seeing, I'm not sure if this was on the side of the road or if this was at a specific location. Was there a basis for the no return order?
So,
It's
Judge,
not a
it looks-
residence.
Oh, sorry, Judge. It looks like it happened just north of a place called Chen's Kitchen. So there is an address here on the probable cause affidavit. I would just ask in an abundance of caution that there be no return to this location.
Either of these individuals have some sort of tie to that location, or is this just something that occurred on the
I
side
don't
of the road?
believe there's any ties. I believe it just occurred in this area, Your Honor.
A $3,500 bond on count 1. I'm also going to order no victim contact, and I'm also going to order that Mr. Cassidy possess no weapons, firearms, or ammunition. Mr. Cassidy, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes.
All right, and I'm not going to impose a no return order at this time because it does not appear that that there's any tie to this specific location that there would be a need for that. Vincent Kelly.
He's approaching, Judge.
Thank you. Mr. Kelly, good morning.
Good morning, ma'am.
You are before the court on count 1, possession of cocaine. Count 2, possession of cannabis, 20 grams or less. Count 3 is driving with a suspended or revoked driver's license. I find probable cause, and I will hear from the parties if they wish to make argument.
Judge, nothing to request from the defense.
Thank you.
And nothing to add from the state as well.
All right, in light of that, I will leave the standard bond in place. Thank you.
Call your sister Sims to get out of here. Good luck, sir.
Evans Matherin. Good morning, Mr. Matherin. You're before the court on 1 count of burglary of an unoccupied structure, unarmed. I find probable cause. I'll hear from the parties.
The state would just be requesting a $2,000 bond in this case and a no return order.
Judge, Catherine, he advised me, unfortunately, there's no one that's going to help post his monetary bond. He's basically homeless. He has a friend that sometimes allows him to stay in a laundry room, but no one's going to help post his bond, so we're asking the court to consider releasing him on pretrial release.
State, does he have priors?
None that he pled to, Your Honor. Well, he has one trespass that he pled no contest to, was not adjudicated. But there is a grand theft that was no infoed, a petty theft that was no prost, forgery was no infoed. So the state's okay with pretrial as long as he goes on Elmo. That he has an electronic monitor of some kind.
A GPS?
Pretrial GPS.
Judge, I'd ask the court to reconsider an Elmo. Unfortunately, as I said, there's no stable housing, so that's basically going to hold him here, no bond at the main jail.
All right, in light of the limited history that's presented at this time, I will ROR Mr. Matherin to pretrial release. However, Mr. Matherin, there's a couple of things that you need to understand about that. Number 1, your attorney is going to give you some information about pretrial services. You need to report to them no later than Monday. If you fail to report to them, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right, number 2, if you fail to comply with the conditions that pretrial puts in place, as far as reporting goes or any other conditions they put in place, they can request that pretrial be revoked. So that means that you need to comply with any of the conditions that they set on you. Do you understand that?
Yes, ma'am.
All right, and number 3 is just because you're being released doesn't mean that this is the end of your case. That means it will be your responsibility to keep in touch with your attorneys and the clerk's office to know any future court dates that you need to be present for. That is especially important for you since I'm being told that you don't have a permanent address at this time. Do you understand that?
Ma'am.
All right, thank you. Michael Baleen.
Judge, Mr. Baleen is approaching. He declined the service of public defender. He's going to hire his own private counsel.
Thank you. Mr. Baleen, do you understand that you are entitled to have an attorney represent you for this hearing?
Yes.
All right, and are you declining the services of the public defender at this time?
Yes.
Okay, all right, Mr. Baleen, for the record, you are before the court on 1 count of grand theft. I find probable cause. And I will hear from the state as to bond.
The state is okay with the standard bond that's placed right now and just ask for no victim contact.
Okay.
Open three.
All right, so I'm going to leave the $1,000 bond in place that has already been put there. Mr. Bailey, and I'm also going to impose a no return order because I believe this stems from a single location and a no victim contact order. That means that you are not to return to or have any contact with this location or the individuals that are there. Do you understand that?
Yes.
All right, thank you.
May I ask if you're willing to reduce or drop the bond on my own recognizance?
Mr. Bailey, I'm not going to do that at this time, but your case will be going before a division judge, and you can address any of those issues with the division judge if you need to.
Okay.
Thank you.
Have a seat, sir. If I don't call you, please do not get up and say anything wrong.
Rodnard Belizaire.
I said one of the lawyers.
Who did you call, Judge? I'm sorry.
Rodnard Belizaire.
Okay. He's here present, Judge.
Thank you. Mr. Belizaire, good morning. You're before the court on one count of possession of cocaine. I find probable cause, and I'll hear from the parties if they wish to make argument.
Yes, Judge. And speaking of Mr. Belizaire, I believe he has a clean adult record. He's 18 years old. He currently goes to school. He's going to Maverick High School. He's a senior. He's graduating this year. He has a 2.5 GPA. My understanding is he just took the SATs. He's waiting for his results to come back. Also, he has a family member that's in the Navy that's been talking to Mr. Belizaire as far as joining the Navy. Mr. Belizaire is very interested in that, and actually he went out and spoke to a recruiter. I believe the recruiter that he spoke to is located in Fort Lauderdale, city of Fort Lauderdale. I believe kind of where Fort Lauderdale High School is. He's living with his mother. They rent an apartment in Fort Lauderdale. He's been living at the premises for the past 11 years. His mom works. She basically cleans houses for a living. Judge, considering he has very, very strong ties to the community, this is not a violent offense. I'm going to be first asking for the court to consider a straight ROR on Mr. Belizaire's behalf. In my conversation with him, I don't have any sort of inclination that he's a flight risk or anything. He will be coming to court, so I think he would be a good candidate for a straight ROR.
State.
Judge, the state would at least ask for a pretrial release.
Does he have any priors?
No adult priors, Your Honor, but does have juvenile priors.
All right. I will ROR Mr. Belizaire to standard pretrial. So, Mr. Belizaire, a couple of important things to note. You're going to be getting information from your attorney about pretrial services. You will need to report to them no later than Monday. If you fail to report to them by then a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. Additionally, Mr. Belizaire, even though you're being released at this time, that doesn't mean that this is the end of the case. So it will be your responsibility to follow up with your attorneys and the clerk's office to know any future court dates that you need to be present for. Do you understand that? All right. Thank you. Ricardo Valentin.
Judge, Mr. Valentin is approaching. He declined the services of public defender.
Thank you.
Further, not right now. Judge, can we put on recall?
Yes.
And Judge, at this time, Judge,
Yes.
I need a moment to speak to the rest of the individuals that are here. So if the court would consider speaking to the other jails.
If we're able to do that, then I will do that.
Thank you, Judge.
We're far enough down the list now. Mr. Reedy, do you have any preference as to where we go first? Is there anyone at the other jails? All right, North Broward, do you have anyone left for me for first appearances?
No, Your Honor.
Okay, thank you.
Thank you.
I'll go over to Conti. Okay, Conti, do you have anyone left for first appearances? Conti right now. What was the question from pretrial? Good morning, Mr. Sansalis.
Good morning, Mayor.
You are before the court on a change of charge. The change charge is attempted burglary of a dwelling. State, I just want to confirm with the change of charges. I'd like to confirm to make sure that this is correct.
Correct, Your Honor.
All right, the original charge was burglary of an unoccupied dwelling unarmed. The new charge will be attempted burglary of a dwelling.
Correct.
All right, I find probable cause. And what was the bond and the initial charge set at?
It was $2,500. And the state would just ask that it remain.
All right, Mr. Reedy, anything from you?
No, Your Honor, nothing to add.
All right, then in light of that, I will leave the bond at $2,500. Thank you, Mr. Sansalis. Okay, is there anyone else at Conti? Conti, do you have anyone else for first appearances? I'll take that as a no. Thank you. Do I have anyone at Paul Ryan? Usually that's a no. All right, then until Mr. Romero, I'm sorry? Richard Barker's going to be a medical reset? Let me just pull him out. Okay, so Richard Barker is still on loan. Is there anyone else that we know of that's going to be a medical reset? All right, then let's go on a brief recess until they're ready at Maine, and then once Mr. Reedy, once you hear from Mr. Romero, then we'll come back on the record and finish up. All right, everyone, we're back on. Mr. Romero over at Maine, I'm told that you guys are ready.
Yes, Judge, thank you for giving me that opportunity to speak up, to catch up with my clients.
All right, Mr. Romero, do you want me to continue going down the list, or I still have Mr. McElroy and Mr. Valentin set to the side?
We're ready to proceed on both of them, Judge.
All right, then let's go with Mr. McElroy since he was first.
Mr. McElroy is approaching, Judge. He's here present, Judge, and at this time, because of the nature of the allegations, I'm going to be waiving formal reading of the charge.
All right, very well. I do find probable cause, and I'll hear from the parties. State.
Judge, due to the sensitive nature of the allegations, the state requests a $25,000 bond on each count and a no victim contact, as well as pretrial release with GPS.
Mr. Romero?
Judge, Mr. McElroy was extradited from Georgia. My understanding, Judge, he's been in custody, I believe, since December 29th. He's actually residing in McDonald, Georgia, with his cousin. He's been residing there for about 4 months now. My understanding is his cousin is helping him out. He pays rent about, I would say, it's about $300 per month. Now he is working. He works at a company called Burris Logistics. He's been working there 4 months, and he only gets paid $13 an hour. Fortunately, that job is still waiting for him. Now, my understanding, Judge, I believe in speaking Mr. McElroy, he's looking forward to contesting these allegations. He's adamant about having his day in court and disputing this. He doesn't know anything as far as how his name even came about, but he wants to fight this, Judge. He has prior contact with the criminal justice system, but I believe it's been about 5 years now, back in 2015. He advised me he will be coming from Georgia in every court day to fight this. He's going to be relying on his family to help post his bond, but their financial resources are quite limited. Specifically, his mother is going to be helping him, and she's retired on a fixed income and elderly. So I'm going to be asking the court to consider setting a $7,000 bond on count 1, $7,000 bond on count 2, a total of $14,000 on Mr. McElroy's behalf, Judge.
State, does he have priors?
Yes, Judge. In 2017, he had a possession of cocaine charge, he was in adjudication. In 2011, he had resisting with violence, battery against the Leo, possession of cannabis with intent to sell. In 2011, he had delivery of cocaine. 2009, he had tampering or fabricating evidence, as well as resisting without violence. 2009, delivery of cocaine. 2009, delivery of cocaine again. Same with 2007 and 2005.
The only clarification I want to say is I believe in 2017 is when he resolved his last case, but that offense happened back in 2015. So my understanding, like I said before, I believe his last new law offense was back in 2015, about 5 years ago, Judge.
Let me first ask pretrial, since this is a gentleman who resides out of state, how is pretrial able to monitor him out of state? Mr. Romero, is he going to have some place to stay here in Florida if he's placed on pretrial with a GPS?
Judge, his mother does actually live here and reside in Fort Lauderdale. If the court were to order that, he would, but of course, he would be abiding by that court order, but he would, fortunately.
All right. Well, I understand that may not be what he wants, but these are obviously very sensitive and serious allegations. So in this case, I'm going to impose a $10,000 bond on counts 1 and 2. If he bonds, he will be placed on pretrial supervision with a level 2 GPS. There is also going to be a no victim contact order in place. And Mr. McElroy, so that you understand, no victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes, ma'am.
Thank you. All right, and then we'll take Mr. Valentin.
Mr. Valentin, come on up, please.
Mr. Valentin, good morning.
Good morning.
You're before the court on count 1, second-degree petty theft, third or subsequent offense. Count 2 is a traffic capias. This stems from driving with a suspended driver's license. I find probable cause, and I'll hear from the parties if they wish to be heard.
Judge, at this time, I'm going to be asking for a property order so he can have access to his property so he can self-bond.
All right, I'll sign that order. State anything further? All right, I'll leave the standard bonds in place and I will sign the property order. Mr. Valentin, I do see that you have a hearing before your division judge on Monday.
You have a court date on Monday on that second count. Good luck, sir.
LaShawn Fortune.
Mr. Fortune, come on up, please. He's approaching, Judge.
Thank you. Mr. Fortune, good morning.
Good morning.
You're before the court on count 1, premeditated murder. Count 2, throwing or shooting a missile into a dwelling, vehicle, building, or aircraft. I find probable cause for these charges, and I will hear from the parties.
Judge, if I could be heard as to count 2,
Yes.
shooting into an occupied vehicle. In reviewing the probable cause section of the warrant, it appears as though there's no probable cause to believe that the vehicle is actually occupied. I believe the alleged victim was standing outside the vehicle in one paragraph of the probable cause portion, and that is when Mr. Fortune allegedly approached her with the gun and then fired one shot. The bullet apparently hit her car, but it's very unclear from this probable cause affidavit that the victim was inside the car at the time. I think the best that the officer can say is that the vehicle looked like it was moving, and that made it appear as though she was inside the vehicle or trying to drive away. But appearances are not, evidence, and that's not, that element of this crime has not been established by this affidavit.
State, do you wish to be heard?
Yes, Your Honor. Just one moment, please. Your Honor, with regards to count 2, second charge, the state has no problem having that as an unoccupied vehicle and the bond amount to being $50,000 for that one. With regards to count 1, the state is asking for a no bond hold. The state's asking for proof evident presumption great. Based on the facts of this case, there were witnesses who actually saw the defendant shooting at the vehicle in near proximity of where the alleged victim in the case was. And again, the state is requesting a no bond hold on this case. as well as GPS monitor. Yes, Your Honor.
Not from me, Judge. Maybe Mr. Romero might have some. Is the state asking for a no bond hold on count one?
Yes, they're requesting a preliminary finding of proof
Okay.
evident
Well,
presumption grade.
I would object to that, Judge. At this stage of the proceedings, they've introduced no evidence, called no witnesses, and proof evident presumption grade is the highest standard that we have in our criminal justice system. Also, again, I know that there's a witness supposedly. We don't know necessarily who that witness is. There was no other evidence that Mr. Fortune committed this offense. There were no, there's just not enough to establish proof evident presumption grade, Judge. So I'd be asking the court to set a bond for Mr. Fortune.
Thank you. Mr. Romero, anything to add?
Judge, all I can tell you right now is we're asking the court, if the court finds proof evident presumption grade, to consider exercising your discretion and imposing a monetary bond. I do see here the monetary bond, which is currently, I believe, was put in place by Judge Merrigan, $250,000, $250,000. That's something financially impossible for Mr. Fortune or his family. My understanding is he's working. He just got a job at Longhorn as a server. He lives in Miramar. He has family here. My understanding his mother is a hairstylist. That's the person that's going to be helped post his monetary bond. We don't have an objection because of the serious nature of the allegation, having a combination of a monetary bond and supervision. But a $250,000 bond on count one is something impossible for him. We're going to be asking for the court to consider somewhere around the neighborhood of a $50,000 bond on count one, Judge, with supervision.
All right, the allegations that are included within the probable cause affidavit include both a witness statement as well as video footage of the incident. Based on the circumstances, the arguments that have been made, the allegations that are included within the probable cause affidavit, at this time, the court is going to exercise its discretion to make a preliminary finding of proof evident presumption grade as to count one. That will be without prejudice for Mr. Fortune to have a hearing before his division judge. At this time, he will be held no bond on count one. As to count two, which the state has agreed to specifically refer to as an unoccupied vehicle, count two will carry a $50,000 bond at this time. Christopher Lee.
Mr. Lee, come on up, please. He's approaching me.
Thank you. Mr. Lee, good morning. Here before the court on count one, possession with intent to sell, manufacture, or deliver cannabis. Count two is a misdemeanor capias stemming from a charge for possession of cannabis. I find probable cause, and I'll hear from the parties if they wish to make argument.
Judge, yes. Unfortunately, Mr. Lee, he's not going to be able to afford to post a monetary bond, nor his father. Now, he lives in Tampa with his father, where they rent an apartment for the past 5 years. His father's supporting his younger sibling, so financially he can't afford to post a bond. Mr. Lee has been here his whole entire life. He's 24 years old. He just got a job 1 month ago working at Teleperformance, making about $11 an hour. Judge, we're asking for him to be released under supervision of pretrial release.
He has no objection to that.
Does he have any priors?
No, Your Honor, I'm sorry.
All right. In light of this, I will ROR Mr. Lee on both counts to standard pretrial. Mr. Lee, so that you understand, your attorney is handing you some information about pretrial services. You will need to report to them no later than Monday. If you fail to report as instructed, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right, Mr. Lee, additionally, I want to advise you that though you are being released today, that does not mean that this is the end of either of these cases. That means it will be your responsibility to follow up with your attorneys in the clerk's office to monitor any future court dates that you need to be present for. Do you understand that?
Yes, ma'am.
All right, thank you. Raekwon Monroe. Thank you. Mr. Monroe, good morning.
Good morning.
You are before the court on one count of carrying a concealed firearm. I find probable cause, and I'll hear from the parties if they wish to make argument.
Judge, at this time, nothing from the defense. I'm going to be contacting his family plus his bond.
All right, state, anything further from you?
Nothing to add from the state.
All right, in light of that, I will leave the standard bond in place. Ronald Detman.
Mr. Detman, come on up, please.
Mr. Detman, good morning.
Good morning.
You're before the court on one count for failing to stop or remain at an accident involving non-serious injury. I do find probable cause, and I will hear from the parties if they wish to make argument.
Judge, I'm going to be requesting the court consider setting a $2,000 bond on Mr. Detman's behalf. He's 50 years old, been here his whole life. He's working. He's been working for the same contracting company for the past 7 years. He lives in Coral Springs with both his girlfriend and his daughter. His daughter's 13 years old, attends public schools. I'm going to be contacting his friends and family to help come up with a monetary bond. He believes that if using the service of bondsman, they can come up with, if the bond instead is $2,000, that's the reason my request. I believe his last prior contact with the criminal system is about 10 years ago.
Thank you. State.
The state thinks the $2,000 bond is reasonable.
Does he have priors?
Let me check here. Just priors that were no proster dismissed.
He had traffic charges, Your Honor. He had a couple driver license. He had
All right, Mr. Detman, I'm going to impose a $2,000 bond at this time. Thank you. Is Mark Powell? All right, I find probable cause. Thank you.
Judge, Mr. Powell is here present, Judge. He declined the services of public defender.
Okay, Mr. Powell, for the record, you're before the court on one count of grand theft of a firearm. Count 2, carrying a concealed firearm. Count 3 is possession of cannabis over 20 grams. I find probable cause, and I have been advised that your bond has been posted.
Judge, the state would only ask for the surrender of and no possession of any firearm, ammunitions, or weapons.
All right, state, I will grant that request. Mr. Powell, I'm going to put an order in place that requires that you possess no weapons, firearms, or ammunition. If you do have any of those items in your possession, you will need to surrender them until further order of the court. Do you understand that?
Yes, ma'am.
Thank you.
Good luck, sir. All right, thank you, sir.
Willie Henley.
Thanks for approaching, Judge. Good morning.
Good morning, Mr. Henley.
Good morning.
You're before the court on one count of possession of cocaine. I do find probable cause, and I'll hear from the parties if they wish to make argument.
Judge, we're going to be requesting pretrial release. He's 42 years old, been here his whole life. He's not working. He's on disability. He gets $771 a month. He lives in Palmetto Beach with both his wife and his son. His wife is not working, so right now they're just depending on him to survive. But right now, no one's going to be able to come up with his monetary bond, so that's why we're requesting pretrial release.
State.
The state has no objection to that.
Does he have any priors?
Just a previous possession of cannabis.
All right. Mr. Henley, I'm going to ROR you to standard pretrial release. Your attorney is going to be handing you some information about pretrial services. You will need to report to them no later than Monday. If you fail to report to them as instructed, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right, and secondly, Mr. Henley, as you probably heard me advise multiple people today, though I am releasing you today of your own recognizance, you need to understand this is not the end of your case. That means it will be your responsibility to remain in contact with your attorneys and the clerk's office to monitor any future court dates that you need to be present for. Do you understand that?
Yes, ma'am.
And,
All right.
and Judge, in this case, the state would just also be asking for random drug testing while on pretrial,
Well, he's going to be on standard pretrial.
and that includes random
Standard
drug testing.
pretrial can do that? All right, then I will agree with that condition. Mr. Henley, you're going to be on standard pretrial, but because of some of the allegations and the one prior that have been referenced by the state in this case, I am going to have you subjected to random testing. That means no alcohol, no intoxicants during this time. Do you understand that?
Yes, ma'am.
All right, thank you very much. Patrick Ware?
Judge, medical reset.
Thank you. Felice Tufano?
Mr. Tufano, come on up, please.
Good morning, Mr. Tufano. You are before the court on a parole violation. This has a no bond hold. I find probable cause. Mr. Tufano, you will have to go before the parole board to determine what will happen with this matter. Jordan Santiago?
He's approaching, Judge.
Thank you. Mr. Santiago, good morning.
Good morning.
You are before the court on 2 add charges. Count 3 is throwing or shooting a missile into a dwelling, vehicle, building, or aircraft. Count 4 is a felony probation violation with a no bond hold. I find probable cause, and I will hear from the parties as to count 3.
The state is asking for a $2,500 bond at this time.
Judge, nothing to have defense considering as a no bond hold.
All right, in light of that, a $2,500 bond will be placed on count 3. The no bond hold will remain on count 4. And Mr. Santiago, you have a hearing before your division judge on Monday morning. All right, that concludes our morning session for first appearances. I'll see everyone back here this afternoon for our afternoon session. Thank you.